The Constitution of the Republic of South Africa, 1996. As adopted on 8 May 1996 and amended on 11 October 1996 by the Constitutional Assembly. Chapter 14, General Provisions, Other Matters. Page 125. Self-determination. Section 235. The right of the South African people as a whole to self-determination, as manifested in this Constitution, does not preclude, within the framework of this right, recognition of the notion of the right of self-determination of any community sharing a common cultural and language heritage within a territorial entity in the Republic or in any other way determined by national legislation. In this context, self-determination refers to the right of the South African people to govern themselves and shape their political and cultural future as a unified nation. The Constitution acknowledges this right while also allowing for the possibility that distinct communities who share a common cultural and language heritage may seek recognition of their own form of self-determination. This could mean maintaining and developing their cultural identity within a certain area or through other means, but always within the legal and constitutional framework of South Africa. The provision does not grant an automatic right to territorial separation or independence. Rather, it allows space for communities to preserve their cultural and linguistic uniqueness as long as it aligns with national legislation. Now, in its entirety, this is the meaning of Section 235 of the Constitution of the Republic of South Africa. Section 235 of the Constitution of the Republic of South Africa addresses the complex issue of self-determination in a democratic and multicultural society. It affirms that the South African people collectively have a right to self-determination, which means they have the authority to govern themselves and shape their own political, social, and economic destiny within the framework of the Constitution. However, this section goes further by recognizing that this overarching right to self-determination does not exclude the possibility that specific communities within the country, those that share a common cultural and language heritage, may also have a form of self-determination. This could mean a form of autonomy or self-governance within a defined territorial area in South Africa, or possibly through other means. Such recognition and implementation of community self-determination must, however, be done through national legislation. In essence, this section opens the door for communities with distinct cultural and linguistic identities to pursue self-determination in ways that respect the unity of the Republic, provided these efforts align with national law and do not undermine the broader constitutional order. Welcome back to the channel where facts matter, truth is paramount, and the Constitution is never cherry-picked to serve political agendas. Before diving into today's explosive and enlightening discussion, be sure to join the channel membership, support with a super thanks donation, and please, let those ads play through for at least 30 seconds. Every bit helps continue to bring unfiltered, fact-driven content that the mainstream avoids. Today, the focus is on one of the most misunderstood, misrepresented, and politically manipulated issues in South Africa, the existence and legitimacy of the communities of Orania and Kleinfontein. Despite repeated attacks from politicians like Julius Malema and his economic freedom fighters, and more recently the MK Party, the truth remains unshaken. These communities are not only lawfully constituted, but their very existence is embedded in the South African Constitution. To begin, consider the legal foundation underpinning these Afrikaner communities. Section 235 of the Constitution of the Republic of South Africa explicitly provides for the right of self-determination for a community sharing a common cultural and language heritage. It is not ambiguous, it is not optional, it is a constitutional right. The framers of the Constitution, fully aware of South Africa's diverse cultural fabric, enshrined this clause to protect minority rights in a democratic framework that values unity in diversity. Orania and Kleinfontein have built their existence on this clause, not in defiance of the Constitution, but in accordance with it. Orania was founded in 1991. And Kleinfontein followed in 1992. Both were developed by Afrikaner communities seeking to preserve their language, culture, and identity in a peaceful, constructive way. These communities are self-sufficient, non-violent, economically viable, and most importantly, open about their legal basis for existing. They are not militias. They are not separatists. They are examples of cultural self-determination functioning within the bounds of South African law. Yet despite this legal clarity, recurring and inflammatory rhetoric continues from Julius Malema and his EFF supporters, who brand these communities as racist and call for their dismantling. It must be asked, are they ignorant of the Constitution? Have they not read Section 235, or do they simply not understand it? Or perhaps, more concerningly, they are fully aware of the Constitution, but choose to disregard it in favor of populist rage-baiting, targeting lawful communities for political capital. This behavior is not only reckless, it borders on unconstitutional. When political leaders incite hatred or threaten legally constituted entities, they do not merely express controversial opinions, they potentially violate the rights of those communities. Malema and the EFF's ongoing threats could very well fall under the definition of hate speech or incitement to violence, both prohibited by the Constitution and various pieces of legislation. Moreover, repeated calls to dismantle communities like Orania and Kleinfontein without due legal process amount to political intimidation, which is itself unlawful. Orania and Kleinfontein have every legal right to seek recourse through the courts. In fact, it would be within their constitutional and human rights to pursue defamation suits, civil claims, or interdicts against individuals or groups, be they the EFF, MK Party, or any other political faction, that attack their existence without legal justification. The Constitution does not grant immunity to political figures when their words endanger the rights of other South African citizens. Let it not be forgotten, self-determination is not secession. Orania and Kleinfontein are not separate states. They pay taxes. They abide by South African law. They simply manage their own local affairs in ways that align with their culture and values, a model that echoes other multicultural democracies around the world. Switzerland, Canada, and Belgium all have communities that exercise cultural autonomy. South Africa is no different, and to suggest otherwise is to reject the very principles on which the nation was rebuilt in 1994. It's time the narrative shifted. Orania and Kleinfontein are not relics of apartheid. They are communities practicing democracy, enterprise, and cultural preservation within the legal framework of post-apartheid South Africa. Those who target them are either constitutionally illiterate or intentionally divisive, weaponizing ignorance for political gain. Citizens must hold all political leaders accountable, not just for what they promise, but for how they act and what they say. Ignorance of the law is no excuse, and neither is populist demagoguery. Communities like Orania and Kleinfontein should not be condemned. They should be protected as proof that constitutional democracy works even for cultural minorities. If this video has been informative, empowering, or eye-opening, don't forget to join the channel as a member. You can also support directly by donating via Super Thanks. And please, let those ads play for at least 30 seconds to help sustain this independent platform. Your engagement keeps it going. Until next time, stay informed, stay constitutional, and stay free.